Hi, Phil Hundelback. We're here with our condemnation process video series. We're on step number 4. We're working our way through, just looking at each step, breaking it down, me giving some more information to you, the landowner, so that you can be more familiar with what's going on in this step. What do you as a landowner need to be doing or thinking about during this step? So number 4, I'm going to call it, this is the step of the petition. So sure, you get the initial offer, you get the final offer. Sometimes initial offer, final offer exactly the same. Sometimes the initial offer is higher than the final offer. Or sometimes the final offer can be a little confusing in that it will have, kind of the final offer number, but then, oh, by the way, this is the number that our appraiser says, which could be much lower. So, once again, talk to your attorney about the different numbers and what they mean and how you should view those numbers. But now at step 4, if an agreement has not been reached, and most of the time agreement will not be reached. Lots of different circumstances. Everybody has, all landowners have different circumstances as to whether they're more inclined to reach a settlement early on or later. But let's just say you're now here at step 4 and a petition has been filed. Now we talked about a time frame, and the condemnor cannot send you the final offer letter and then the next day file a condemnation petition for condemnation. You have to wait at least 14 days after that final offer packet has been sent to you. So pay attention to those deadlines. Most of the time, condemnors comply with those timelines, or I don't so much deadlines, but timelines. Now, what you as a landowner should look at when you get the petition, you probably will get served with the petition. If you have an attorney, your attorney will most likely get a copy of the petition as well from the condemnor. Oftentimes, attorneys will, work with and discuss with the condemnor's attorney about waiving service, so you're not, woken up early in the morning by some process server getting you served with the condemnation petition. But regardless, and this happens all the time, even if your lawyer, the landowner's lawyer, says, please don't serve my client. I'll accept service. Send it to me. No worries. Sometimes, as I've said before, the left hand doesn't know what the right hand's doing, and you may still get served with the petition for condemnation. Why do condemnors do that? Probably just to cover themselves and make sure that you get served. Take a look at the petition and make sure that the petition, matches what you understand the taking is or will be from the initial offer letter and the final offer packet. So going back to sometimes we see petitions that vary from what the final offer letter and the appraisal said on the taking. And if that's the case, then definitely bring that up to your attorney. Your attorney will undoubtedly have looked at the petition as well, and that's something that can be discussed. So also, always remember, so there's a proposed easement, for example, in a pipeline, a proposed easement versus what the terms and conditions are in the pleading. And they don't always match. Sometimes the proposed easement terms are more favorable than what's in the pleading, or the pleading is much more broad and gives much more broad rights and authorities to the condemnor. So when you get the petition, just review it. It'll be multi-pages long. Take a look at it, review it, read it, and pay close attention to what's being taken. And is it the same as what you've understood, frankly, from the very beginning? That takes care of step 4. Let's move on to step 5.